Hello and welcome to the Patent Agent Preparation Series. My name is Prigya Arora. I am an engineer turned intellectual property lawyer. In the last video, we discussed about patent publication. In this video, we'll discuss about secrecy provisions and foreign filing license. So let us directly dive deep into this. So, secrecy directions, why these are important? There may be some inventions which are related to defense purposes, and because that may hamper security of a country, we have some secrecy directions. Whenever these directions are imposed, the patent application generally does not get published for that time period. The relevant sections for secrecy directions are 35, 36, 37, 38, and Rule 72. We'll also cover aspects of foreign filing license or the foreign filing requirements today. And this requirement is there. Why? Because if you are being an Indian resident, file an application outside India without filing your application in India, then we need to seek permission from the government. And this permission is called foreign filing license or foreign filing requirement. So relevant section of this are section 39, rule 71 and form 25. And other relevant sections which are read with secrecy provisions and foreign filing requirement are section 40, 41, and 42. So we'll cover these provisions very briefly. And this is important again for the purpose of objective questions. I don't think there is an opportunity to ask a subjective question here, but for objective question, I think it can come from foreign filing requirement or any timeline or process associated with secrecy direction. So I'll open the act now so that we get clarity on what is written in these sections. So let us begin with section 35 of the Act, which I think is the most important section regarding secrecy directions. And I'll just briefly tell you what happens here, and then you can go through the Act yourself. For example, there is a patent application filed which the controller thinks is related to defense purposes. So in that case, the controller will notify to the central government that we have this application and it appears that it is related for defense purposes. And based on that, he may give directions for prohibiting or restricting publication of information which is mentioned in the patent application. So whenever there is a patent application which may relate to or which may be relevant for defense purposes, the controller will send a notification to the central government, and then he will prohibit or restrict the publication of the information which is given in the patent specifications. So let's go through subsection 2, where the controller gives any such directions as referred to in subsection 1. He shall give notice of the application and of direction to central government. And then central government shall, upon receipt of that notice, consider whether publication of the invention would be prejudicial to defense of India or not. If upon such consideration it appears to it that publication of the invention would not so prejudice, give notice to the controller to the effect, who shall therefore thereupon revoke the direction and notify the applicant accordingly. So whenever this happens, the controller will give direction to central government. The central government will decide whether this invention relates to defense of India or not. If it relates to defense of India, the central government would be of the opinion that it should not be published. If central government thinks that okay, it is not prejudicial to defense of India, the central government will ask the controller that it is okay, you can revoke these directions, and the applicant would be notified accordingly. Then in subsection 3, we have the prejudice to the provision contained in subsection 1, where central government is of the opinion that an invention in respect of which the controller has not given any direction under subsection 1 is relevant for defense purposes. It may at any time before grant of patent notify to the controller to that effect, and thereupon provisions of that subsection apply if invention were one of the class notified by central government, and accordingly the controller shall give notice to the central government of the directions issued by him. So there may be chances that on certain applications the controller does not apply the secrecy provisions. In that case, what will happen? If the central government thinks that such application should not be published, they may tell the controller that you should employ secrecy directions on this and this application should not be published. So the central government can also give such notifications. So let's now come to section 36, which is secrecy direction to be periodically reviewed. So it just mentions that whenever there are secrecy provisions levied under previous section, which is section 35, it shall be considered by the central government at intervals of 6 months or on request made by the applicant, which is found reasonable by the controller. So this just means that at every interval of 6 months, the central government should see whether this application is still prejudicial to defense purpose or not. So if it is not, the central government will lift the secrecy direction. Otherwise, they'll ask the controller to keep the secrecy directions there only. So one case is this. Another case is there might be an invention which is already published outside India. Like a foreign national has applied the invention and it has it has been published outside India. In that case, what will happen? The controller has to publish the invention or revoke the secrecy direction. Why? Because the application is already published outside India, so there is no point of keeping it confidential in India. So therefore we have this clause that in case of an application filed by a foreign applicant, it is found that invention is published outside India, it shall forthwith give notice to controller to revoke direction, and the controller shall thereupon revoke the directions previously given by him. Then the result of every reconsideration under subsection 1 shall be communicated to the applicant within such period and such manner as may be prescribed. And what is that period? This period is 15 months. So the result of every reconsideration under subsection 1 of section 36 shall be communicated to the applicant for a patent within 15 days of receipt of notice of by the controller. So what is this time period? This time period is 15 days. So section 37 is about what happens when there are secrecy directions. So what is the importance of secrecy direction? What happens if there are secrecy direction? That is mentioned in section 37. So long as any direction under 35 are in force, the of an application, the controller shall not pass an order refusing the grant of the same. So this is also important. Why? Because whenever there are secrecy directions, the controller will not refuse your patent. It will not grant your patent because the patent is not published. So the controller cannot pass an order to refuse to grant of the same. That means the controller is not currently taking any action on your patent. Then, notwithstanding anything contained in this act, no appeal shall lie from any order of controller passed in respect thereof. So there shall be no appeal from any order of the controller passed in respect of the applications which are filed, which are currently under secrecy. So there may be a situation that Secrecy provisions are applied after a certain time by the central government itself. So in that case, if controller has passed certain order, there shall not be any appeal, provided that application may, subject to direction, proceed up to the stage of grant of patent, but the application and specification found to be in order of grant of the patent shall not be published, and no patent shall be granted in pursuance of that application. So it may happen that examination of your application has been taken place, but because the application is not published, the patent would not be granted. And so regarding this clause, if any application is currently pending under secrecy direction, we cannot get a patent on it. So no patent shall be granted in pursuance of that application. Now, let's come to subclause 2, where a complete specification filed in pursuance of an application for a patent for an invention in respect of which directions have been given under section 535 is found to be in order for grant and patent during the continuance in force of the direction. Then, if during continuance in force of the direction, any use of invention made by or on behalf of or to the order of government, the provision of section 100, 101, 103 shall apply in relation to that use if the patent has been granted for the invention. So this subsection simply means that if there is any use of an invention made on behalf of the government while the secrecy provisions were applicable on the invention, that use would be considered as government use. So section 100, 101 and 103 are for the purpose of government's own use. So that means the government is using the invention. So let's come to B. If it appears to the central government that applicant for the patent has suffered hardship by reasons of continuance in force of any directions, then the central government may make him such payment by way of solatium as it appears to the central government to be reasonable, having regard to the novelty and utility of the invention and the purpose for which it is designed, and to any other relevant circumstances. So because these secrecy provisions were applicable, the applicant was not able to use the invention or commercialize the invention. But there might be situations where central government is using this invention, and in that case, what may happen? The central government may compensate the applicant of the patent. Why? Because the central government is using this invention. So that is also possible. Then we have subclause 3, which says where a patent is granted in pursuance of an application in respect of which directions have been given under section 35, no renewal fee shall be payable in respect of any period during which those directions were in force. So if the patent is granted, firstly, it is very difficult to get a patent granted in this scenario when secrecy directions are applicable. Still, if the patent is granted during that tenure, or it may happen that your patent is in examination stage and at that point only secrecy directions were invoked by the central government. So in any case, if there is any renewal fee due at the patent office for the period of time your application was under secrecy provision, for that period you do not have to pay a renewal fee. So ideally the renewal fee starts at a time period, at a certain time period after from the date of filing. So that time period also will not start because your application is under secrecy directions invoked by the government. So section 38 is about regarding extension of time. So whenever any direction under section 35 is revoked by the controller, then notwithstanding any provision of this act specifying the time within which any step should be taken or any act done in connection with the application for patent, the controller may, subject to such conditions if any, as he thinks fit to impose, extend time for doing anything required or authorized to be done under this act in connection with application, whether or not that time has been previously expired. So this is simply means that you can seek extension of time in case certain things need to be done and that were not done because of the secrecy provision. So important rule here is just rule 70 2, which says a period of 15 days. Within that period, the note with reconsideration should be communicated to the government. So this was about the secrecy directions, and it is fairly very simple to understand that whenever there is a secrecy direction, the patent application for that period would not be published and there would not be any action on your application. And this is one of the most important aspect that needs to be remembered. Next, we'll come to foreign filing requirement or foreign filing license. Again, I think there is a scope for an objective question from here, and maybe a short answer type question can come in which there is a scenario, and probably the answer would be that we need to apply for a foreign filing license under this section. So let me tell you the concept of foreign filing license. So for example, I am a resident of India and I need a patent in the US. And what will happen if I want to take a patent in US without informing Indian government? I have done research in India. That is my idea, my invention. I have developed an invention in India and I want to take a patent outside India in the US, and I don't want to inform government, Indian government body regarding it. This cannot happen. So what is the scenario here? That I want to get a US patent. So what would the government require? The government would require either I first file a patent in India. If I'm not doing this because I don't want to commercialize my invention in India, at the same time, because I don't want to bear cost of patent filing in India. India is not my market. I want to file directly outside India. In such case, what I can do? I should apply for a foreign filing license, or I should abide by foreign filing requirements which are mentioned under Section 39 of this Act. So Section 39, Rule 71 and Form 25. So a direct question may come that what is Form 25 and why Form 25 is filed. So you need to remember Section 39, Rule 71 and Form 25. These are the three elements of foreign filing requirement. So let's go through this section once, because there is only one section regarding foreign filing requirement. No person resident in India shall, except under authority of a written permit sought in the manner prescribed and granted by or on behalf of the controller, make or cause to be made an application outside India for grant of a patent for an invention, unless an application for a patent of the same invention has been made in India, not less than 6 weeks before the application outside India. So, what does this mean? This means that if I want to file a patent outside India, what I need to do? I need to obtain a written permit. If I'm not obtaining a written permit, then my application should be filed in India, and there has to be a gap of 6 weeks between filing the patent application in India and filing the application outside India. So a question may come that what is the time period to file a convention application? So the answer would be like, if I am an Indian applicant and I want to file a convention application in the US, what would be the timeline? So the ideal timeline should be between 6 weeks to 12 months, because there is a waiting period of 6 weeks mentioned in this subsection. If you do not want to wait for 6 weeks, then also a foreign filing license would be required. Or if you do not file an application in India, you are filing directly in the US, then also a foreign filing license would be required. Second subclause is either no direction has been given under section 35 in relation to the application in India, or such directions have been revoked. So it is necessary that there is no secrecy directions on this application. Similarly, if you want to file a PCT international application under PCT, in that case also, if you are filing first application in India and then you are filing an international application under PCT, then also the timeline is within after 6 months and within 12 months. So ideally, that is the timeline to file your international application. Next, we have the controller shall dispose every application within such period as may be prescribed, provided that if invention is related to defense purpose or atomic energy, the controller shall not grant permit without consent of central government. So what does this mean? The time period mentioned here is of 21 days. So in rule 71, the timeline mentioned here is the controller shall dispose the request made under subrule 1 within a period of 21 days from date of filing of such request. So whenever you ask for a permit under form 25, your answer should come in 21 days. So this is the timeline. Within 21 days, you will get yes or no from the government. And when can government say no to you? They can say no to you when your invention relates to defense purposes or it relates to atomic energy. Then the government will say that because your invention relate to defense purposes and atomic energy, we don't want you to file your patent application outside India. As it is, they are not permitting us to proceed with the application in India, because in India, if we file, they'll imply secrecy provision. So if we try to file outside India, if it is related to defense purpose or atomic energy, they'll not give us this consent. Then we have subsection 3, which says this section shall not apply in relation to an invention for which an application for protection has first been filed in a country outside India or by a resident outside India. So if a resident outside India is filing an application outside India, and then they are filing the application in India, then this section will not apply. Why? Because this section is applicant to Indian residents only, and the preamble of it also says that residents should not apply for patent outside India without permission. So if you need to apply for a patent outside India without permission, then you can do it after filing in India and after waiting for a period of 6 months. Then you can apply. But if you want to apply if you want to file an application outside India without prior permission, then you should do it after filing your patent application in India and after waiting for a period of 6 weeks. If you do not want to wait for a period of 6 weeks, or you do not want to file your application in India, in that case, this permit would be required. Therefore, you should ask for this permit if you are thinking of applying your patent outside India. So now let us have a look at what is the liability. For example, you contravene provisions of secrecy, or you file your application outside India, but you do not take a foreign filing license. Then under section 40, there is a liability which is without prejudice to provision contained in chapter 20. If in any respect of application for a patent, any person contravenes any direction to secrecy given under section 35 or causes or makes or causes to be made an application for grant of a patent outside India in contravention of Section 39. That means you have not taken a foreign filing license, then the application for patent under this act shall be deemed to have been abandoned. The patent granted, if any, shall be liable to be revoked under Section 64. If there is a application, the application would be considered as abandoned, and if the patent has been granted, it would be considered as revoked. I think one of the important questions that you may be thinking is, what is the contravention for secrecy provision? For example, if you're not complying with Section 35 or you're not complying with Section 39, that means you're not taking the required permission for filing your patent application outside India. Then I think one reason to worry is Section 118, which says, like, if there is any contravention of Section 35 or Section 39, then the person shall be punishable with an imprisonment for a term which may extend to 2 years, or fine, or both. So, because of this penalty, I think we should always take a foreign filing license whenever we are filing an application outside India, without filing an application in India, or we are filing an application outside India within 6 months of filing, within 6 weeks of filing the application in India. So in these two cases, you should always take permission under Section 39. Next, we have Section 41 and 42. These are also simple sections related to this finality of order of controller and central government, which simply means that all orders of controller giving directions to secrecy as well as orders of central government under this chapter shall be final and shall not be called in question in any court or any ground whatsoever. And Section 42, which is also a simple section, it says savings respecting disclosure to government. Nothing in this act shall be held to prevent disclosure by the controller of information concerning an application for a patent or specification filed in pursuance thereof to the central government for the purpose of application or specification being examined for considering whether an order under this chapter should be made or whether an order so made should be revoked. So this simply means, like, if controller is disclosing your invention to the central government, it will not be considered as publication. It would not be considered as disclosure. It is a savings clause which is saving the controller from the liability of publication or from the liability of leaking the invention outside to an out body. So if controller is telling your invention to central government, that is allowed and the controller would not be liable. So I think these are the relevant sections related to secrecy provisions and foreign filing license. One of the section from where we have a scope of objective questions. So do go through these provisions once. These are simple to understand, not very difficult. And if you have any questions, feel free to write to me. Thank you.